This is the third webinar in the series of new labor codes that have been implemented since 21st November 2025. So I'm sharing my presentation and then we shall continue the topic. In the previous two sessions of these new labor codes, we have seen these are also already uploaded on YouTube. So we have seen that 29 labor laws, central labor laws, have been replaced by 4 new labor codes. And there are still some older laws that continue. Around 21, 22 older laws are there. So we have seen about that also. So I'm not going into details of that. We have seen that instead of around 1200 sections, now it's just 440 sections. So syllabus for law students are around 40%. For the practicing lawyers, it poses a problem as well as a challenge because they have to deal with the older laws as well as the new codes. And since they have been implemented all over India, and now the rules have also been notified. So these draft central rules have been published. So we shall see what are the developments since November 2025 and what are the changes that have happened in last 2 months so that we can update ourselves and how the role of practicing advocates is going to change from litigating lawyers to compliance, that is due diligence advice, that is to an advisory role. Because initially there are not likely to be many court cases. So everybody wants to avoid the penalty and criminal prosecution. So the role of advocates will be in near future will be to advise their clients, corporates about how their role is going to change. For law students, it will be a double problem. They will have to study older laws as well as the newer laws because already going on cases will be as per the older laws to maintain the continuity, and the newer cases after 21st November will be as per the new codes. Further, we have seen that the acts have been repealed, but the rules, regulations, notifications, all under the older codes are still valid. So when the new rules will be notified, the rules will be repealed. When the new regulations will come into effect, the regulations will be repealed. When the new notifications will be notified, the older notifications will be repealed. And like that, the process will go on gradually. And it is happening every day all over India. Because we have seen that labor law is a subject in concurrent list of the constitution. So central government as well as the state government both have the powers. So let us begin with the today's topic. We have to see this compliance framework and digital transformation. So we are going to focus on these two topics. I will not repeat what we have seen in the previous two webinars. Those are already available on YouTube. You can go into details of that. But since the topic is same, that is new labor codes, some repetition is inevitable. So some important things I'll repeat. So we shall see this is a comprehensive guide for legal professionals, that is the law students, and practicing advocates, that is the target audience for this. So we shall see how it affects the careers and this revolutionary law, because many older laws, that is from 1923 to 2008, have been repealed because of these 4 new codes, and the laws have become much simpler now. So we shall see will be very useful to you in your practice. Now we see firstly the overview of the 4 new labor codes. So in the previous session, we have seen that there are pillars or the new labor law reform that were going on since 2019. So the bills were passed by the parliament in 2019-20, but because of COVID and some consultations that was going on with the labor unions and management, it took time. So the rules were being drafted by most of the states, have already drafted those rules also, and then it was decided and these rules have been notified. So the process was going on since last 5 years, and it's not overnight or all of a sudden. So they have come into effect, and we shall see some provisions had already come into effect on 2021 and 2023 also. We shall see that also in this presentation. So firstly, there is Code on Wages 2019. So it was published in August 2019 in Gazette of India. All the 4 bills have been passed by the parliament. They have received assent from the president, and they have been duly notified in the Gazette, and the date of coming into effect has also been notified on 21st November 2025. So it consolidates 4 older laws. So we know that Payment of Wages Act, Minimum Wages Act, and other Equal Remuneration Act, and these laws have been repealed. Next is the Industrial Relations Code 2020. It was published on September 29, 2020. It consolidates 3 laws. So we know that Industrial Disputes Act and the Labor Unions, Trade Unions Act 1926, these have been repealed. And instead of this IR code, that is the Industrial Relations Code, has come into effect. Then there is OSH code, Occupational Safety Hazard and Working Conditions Code. So Factories Act and some other laws have been repealed. We have already seen that in our previous 2 presentations, so I'm not going to repeat that. So it consolidates the older 13 laws. And then there is code on social security. So maternity benefit act has been repealed, some other laws have been repealed, and instead of that, the code on social security, so EPF, ESI have been repealed, and instead of that, there are all the things are included in social security. Just like in Western countries, as soon as a child is born, there is social security number that is given to the child, and that remains valid throughout the life. So here also the social security is implemented, and we have code on social security 2020. It was also published on the same date, September 29, 2020, and it consolidates 9 laws. And like that, like this, 29 old say central laws have been repealed, and now these 4 codes have come into effect. Enforcement timeline and current status. So key implementation dates, as we have seen, the labor codes came into force in their entirety. Some provisions had already come into effect, like in 2021, the CAB, Central Advisory Board, was notified, but that was not noticed by many people because the new laws were published in the Gazette, but they were not implemented fully. Then in 2023, because of Supreme Court order, some provisions related to EPF and ESI had already come into effect. And there was some confusion when these 4 codes were implemented on 21st November, that why some sections have not been implemented. So on December 19, 2025, the central government has cleared the confusion by notifying that some provisions had already come into effect in 2021 and 2023, and those have been listed. And for EPF and ESI, they have said that some provisions will they will remain valid for 1 year. That means after November 21, 2026, all the these provisions related to EPF and ESI will also come into effect. So to continue the benefits that the employees are receiving under the older laws, to maintain that continuity, 1 year has been given. That is the timeline for implementation. So this corrigendum was issued clarifying that complete repeal of subsumed laws, because that was not clear and there was some confusion why these laws have not been repealed, or why 2 codes, some sections have been dropped. So they have clarified that they were already implemented in 2021 and 2023, although that was not noticed by many people. Now there is no transition period, so immediate applicability within without any buffer time. Then the rules notification status, because there are central rules and there are state rules also. So central rules have already been, draft rules have been there, and final rule notified. So as far as the state rules are there, so final rules have been notified by some state governments like Gujarat, Arunachal Pradesh, Bihar. So all 4 codes. There is different progress, and what which states have implemented fully, which states have not, that we have already seen our second presentation. So I'm not going to repeat that. Partial rules, that is out of 4 codes, partial rules have been found by Karnataka, that is IR code, and wage codes, except that is IR code. So they have been implemented. West Bengal has not implemented any of the 4 codes. So no rules have been found by them, and draft central rules have been notified, and most other states have notified the draft rules. And as I have told, the codes have replaced the act, and when the rules will come into effect, they will replace the older rules. Until that time, as per the repeal and savings clause, that is the last section of all the 4 labor codes, the older rules, regulations, notifications, government orders, office orders will remain into effect, provided they are not contradictory with the newer laws, newer codes. So this is the corrigendum that was issued December 19, 2025. So Ministry of Labour and Employment, all these 4 codes are available on this MOLE, that is MOLE website, and these notifications are also available on this website. Besides that, you can refer for your local or state laws, you can refer to your labor department of your own state also, because there could be some changes from state to state. So for that, you will have to refer to your website of your own state. So it was issued, Ministry of Labour and Employment issued a significant corrigendum referencing this ASO 5319E Extraordinary Gazette dated November 21, 2025, through which this had come into effect, that clarified and strengthened the enforcement of the new labor codes, confirming the comprehensive repeal of 29 existing central labor laws. Only for EPF and ESI, they have said that they had already come into effect because of a central Supreme Court order, and they will continue for 1 year under the older laws, because there should not be any discontinuity of benefits to the employees. So this clarification was issued by the central government, and on repeals, the corrigendum confirmed that the 29 older labor laws, such as Factories Act 1948, Payment of Gratuity Act 1972, were officially repealed with effect from November 21, 2025 upon the implementation of the 4 new codes. Next we see Social Security Code Focus, SS Code. So the update address, that is on 19 December it addressed the ambiguities in the Code on Social Security 2020, because the confusion was that whether it has been implemented fully or not. So it was clarified by the government by refining the enforcement codes of specific sections regarding the say Employees Provident Fund, that is EPF, and Employees Pension Scheme, that is EPS. As far as the EPF Act is concerned, we are not talking about government employees for which there is GPF. We are talking about the Employees Provident Fund, that is the 1925 law, not the 1952 law, not the 25 law that is applicable to government. So there are two different Provident Fund Acts. So here we are talking of the newer, this 1952, that was there when the Industrial Revolution came in India after independence. So EPF had transition. So while the EPF had 1952 is say largely superseded, the corrigendum clarified. It said that related updates clarified that existing PF, pension, and say EDLI schemes, they will continue in force for a transition period of 1 year, that is November 21, 2026, after which they will be completely subsumed by the newer codes. As far as wage computation is concerned, so there was some confusion how it is to be computed. So contributions during this transition period must now be say computed based on the say definition of wages under the new Social Security Code, that is the new SS code, with effect from 21st November 2025. So this corrigendum aims to ensure say regulatory clarity and prevent say misinterpretation of the newly implemented labor framework. So I hope this clarifies. This was the recent notification or corrigendum. Now we see this philosophical shift in compliance. Firstly, from Inspector Raj to ease of compliance. We have seen that inspectors are now renamed, say redesignated as Inspector-cum-Facilitator. So there will not be any direct penalty, but there will be notice and they will give compliance time. So the emphasis is on voluntary compliance by the employers. So key paradigms changes are there. Firstly, there is decriminalization of minor offences. That is, instead of imprisonment, has been say changed in most of the cases, and it has been changed to fine, penalty. So imprisonment reserved for serious infractions only, and first time violations, there are monetary penalties. And as we know, in law generally there are enhanced penalties if there are repeat offences. Secondly, emphasis on say facilitation over punishment, so that there is voluntary compliance. So there is, instead of Inspector Raj, there is now Inspector-cum-Facilitator model that is there. Just like we have designations like factory welfare officer under the older act. So now in the government or in Ministry of Labour and Employment, there will be inspectors-cum-facilitators. So they have been renamed or redesignated. Opportunity to rectify before prosecution. That means they will point out the violations, that this is the violation, and within this time you have to comply with this, so that there are no penalties. And that is where the role of advocates will come, because they will advocates will also have to guide their clients regarding due diligence provisions. Then digital first approach. That means many things have to be done online. So in this presentation, we shall focus mainly on what are the things like say Shram Suvidha portal and many other things that are going to be online. There will be online inspection, online audit, many things will be online. So we shall see about that also. So there is single registration portal will be there. So instead of 8 different types of registrations required under the older laws, there will be single registration. There will be web-based inspection instead of physical visits by the inspector. Web-based inspection. That means they will check your website. Then there is electronic maintenance of records. So instead of manual registers, there will be electronic registers. And minimum government, maximum governance. As per the government's motto, so there is self-certification mechanism. So what is self-certification? How to do it? That we shall see today in detail. And deemed approval provision. So we shall see what is deemed approval and how to do it. Next we see the common registration portal. So for common registration, now we know that there will be say common registration for say different types of say registration. That is single registration instead of the previous 8 registrations. So single registration system architecture will be there. Unified registration framework. So legal provisions, we shall see what is the basis. For SS code, it is section 3, that is electronic registration. Under OSH code, it is actually occupational safety and health and working conditions. So we shall call it OSH code. Section 9 provides for common registration. Under the IR code, section 9, there is registration of establishments. So key features are single window registration. That means once it is done, it will be done under or 4 codes, or we can say 29 older laws, because 8 different registrations were needed earlier. So one registration covers all applicable codes and electronic to or otherwise as prescribed. So in some cases it will be electronic, in some cases it will be manual as prescribed. Prescribed means prescribed by rules of central government or maybe say state government of your state. Then there is provision of deemed registration. So existing registrations under say repealed laws deemed valid. That means although new laws have come into effect on 21st November, you don't have to rush to the Labour Department overnight. All your older licenses registration will remain valid until their expiry date. And once they expire, then the employers will have to go for the newer registrations. When they go for renewal, so at the time that will be under the new, so that there is no burden on the Ministry, Department of Labor, Labor and Employment also. No need for fresh registration if it is already registered. So there is no panic-like situation, so that there is gradual transition. Registration validity, so continuous validity unless it is cancelled, and automatic updates through the portal. So it will be e-registration now. That means there are no physical visits required to the Labour Department. Next, we see the registration process details. That is how common registration works. So there is the step-by-step process. Firstly, there will be portal access. Portal means entrance page of a website. That entrance page is called a portal. That is the home page, we call it. So port means entrance in English. And from port, the word has come portal. So in simple English, port means entrance. So entrance is from where you enter the website, homepage. So employees access is there is unified digital portal that is implemented, and single interface for all compliance needs. Already these have been implemented by the central government, that is the MOL website, as well as the websites of labor departments of your respective states. Then information submission, it has to be done online. So basic establishment details, of course it has to be done once only. Employee worker count, nature of business or industry, and applicable code provisions, because now it will be a single registration. Next, we see automatic assessment. So system determine applicable provisions. That means system will determine and advise you, just like we do in case of income tax when we file the returns. So it will advise you. Then calculates say thresholds. For example, PF 20 plus, ESI 10 plus, etc. Definition of factories are also changed now. So instead of 10, there should be if there are more than 20 workers, then only it will be called a factory. If you are using power, that is electrical power, instead of 20, now it will be 40. If you are not using power, that is electrical power. So definition of factory has changed. So we have to see all these definitions under section 2 of the 4 codes, that is factory, establishment, workers, wage, gig workers, platform workers, etc. We have already covered some of that in our previous two sessions. Now the registration certificate. So there is digital certificate that will be issued. That means you can download, you can print, and you can display on say your website, or maybe physically within your establishment or industry or factory. Unique identification number is assigned, so that identification number will be there, just like earlier there was done under EPFO, Employees Provident Fund Organization. Continuation of old registration. This we have seen. This is as per the saving clause. So section 164(2) of SS code, existing registrations will continue. They are all valid. You don't have to rush overnight to the Labour Department. When it will expire, so at that time you will get registration under the new code before that expiry. So must provide details to registering officer within prescribed timeline. Prescribed means prescribed by rules. So the rules will supersede or say repeal the older rules, and then that will have to be complied. And that process has already started all over India in different states. So we have to be vigilant about that. Now deemed approval. What is the deemed approval? So let us see that there is self-certification and deemed approval mechanism. This is something new under the new codes that was not there under the older laws, labor laws. So this is a revolutionary concept. Approval by default. That means if nothing adverse is communicated, you can deem that it is accepted. Just like when you don't get notice from income tax department, your registration say okay, directly you get refund in your account. And now there are even faceless say assessment, so that you don't come into contact with who is the assessment officer, and there is no chance of bribery or corruption, and even the assessing officer doesn't know who you are. So just like there is faceless implementation, similarly here now it is automatic. There is approval by default. If there is no adverse communication or notice, you can assume that whatever you have done is okay, correct. So legal framework is under OSH code section 9(4) subsection 4. So registration application, if not processed within prescribed time, then it is deemed approved. That means they have to inform you what are the deficiencies or the objections. If there are no objections, it is automatically approved. This is deemed approval. Under OSH code section 9(6), cancellation of registration. So if an intimation is not processed within prescribed time, it is deemed to be cancelled. So there is deemed cancellation also under the OSH code. Under the IR code, Industrial Relations section 31(6), there is standing orders certification. So if not certified within 60 days, that means it is deemed certified. So if there is no adverse communication, you can go ahead, and subject to compliance with IR code requirements. So this proviso is there. Next we see, so these are some new features. The practical impact of this is it prevents undue bureaucratic delays, harassment, corruption, etc., bribery, and reduces compliance burden. It has become easier now, and there is online also. So physical visits are not needed to departments, and empowers businesses with certainty. So this is a new provision. That is how digital transformation has come into effect. Secondly, unified compliance mechanism. So single license and common compliance under OSH code licensing framework. So 3 types of licenses are there. We shall see what are these. So under section 10 of OSH code, there is common license. So factory operations, we know that Factories Act 1948 is now repealed. So there is new definition of factories as per this section 2. And then industrial premises for BD cigar work and engaging contract labor or any combination of above activities. So for that, there will be common license under section 10 of the OSH code. Next, second type of license is work specific license for contractors. So project based work orders. Project is time bound, like say railway electrification, anything that is time bound, we call it project. So it is a time bound. So there is target completion date. So project based work orders. It is not going to be say in perpetuity or in continuous activity. And there are time bound engagements. So for that, there will be work specific licenses. There will be national license, just like there are national permits for say transport, say trucks, etc. So work in more than one state. So there will be national license. It will be pan India say operations and eliminates multiple state licenses. So that is the advantage. That means you don't have to approach the individual state departments, and it will be valid throughout India. Validity of existing licenses. So there is continuity. So licenses under repealed laws remain valid until expiry. Again, you don't have to rush to the labor department overnight. All your older licenses are valid. But once they reach the expiry date, you have to renew before they can be expired. So can be reviewed under the new framework. Now, unified return system. So there will be single return. Instead of submitting many different forms, even the schedules have changed, as we have seen earlier. Instead of say older schedules, 27 schedules, now there are only 14 schedules, including all the 4 codes. So single return filing mechanism is there. Even forms are already there, and some forms, as we know, shall be designed by the central government as the state government when the rules are notified and come into effect. So single return filing mechanism is there. Streamlined reporting. So under the previous regime, it was multiple returns under different laws, different formats and timelines were there, and separate filings for PF, ESI, bonus, gratuity, etc. were there. What has changed now? So under the newer laws, the key features are there is integrated return system. That means there is common return. So single return covering multiple obligations, and there is common format access codes. So across different codes. So there is common format. Then there is electronic filing. So that is the digital transformation part. So mandatory digital submission is there, and integration with common portal. So some portals are there like Shram Suvidha, etc. I have given list at the end. So you can directly fill those, or you can advise your clients regarding this online provisions. So they have to be done online by you on behalf of your clients or by the employers themselves. Reduce compliance burden. So one registration, one license, one return. This is the main motto of this, say, new labor codes as advertised by the government, and simplified reporting requirements. The legal basis of this is in each code, it empowers appropriate government to prescribe return formats. Appropriate government will be for central matters, central government, and for state matters, state government. So for different sections where there are rules, so you will have to study the different rules under the different acts, where the rule making powers are given under the 4 codes. And when the rules are notified or they come into effect or have come into effect, then you have to refer to your state government rules on your respective state government websites. Central government coordination with states for uniformity, that will have to be maintained as per our federal structure in the constitution. Now the Inspector-cum-Facilitator Scheme. So what is the concept? So we have seen that the Inspector Raj, so that has been changed. So instead of inspector, they have been renamed or redesignated as a Inspector-cum-Facilitator. So this is evolutionary role transformation, what we called as Inspector Raj, because there has to be ease of doing business. So just like in 1991, we know that there was LPG revolution, liberalization, privatization, globalization that was brought by Manmohan Singh, the then finance minister in Narasimha Rao government. So now there is going to be another transformation, and this will be role transformation of inspectors that was going on since 1948 or before that. So from enforcement to facilitation, so legal provisions, what is the legal basis? Wage Code Section 51, SS Code Section 130, OSH Code Section 88, and IR Code Section 77. These provide for inspectors, Inspector-cum-Facilitators now. Then the dual role. So we shall see the inspector function is traditional one, that is ensure compliance with code provisions, conduct inspections, and examine records and registers. But now there will be electronic registration, there will be electronic registers, there will be electronic in many cases. And facilitator function, this is a new one. So supply information to employers and workers about their deficiency, what are the new provisions, what they should do You will give time limit, notice or warning before taking any action. Then advice on compliance requirements. So they will also perform advisory roles. And then sensitize the stakeholders about code provisions, that is the new labor codes, and guide towards compliance. So the role has changed. Where the stakes are high, they would seek legal advice also. And at that time, say the role of advocates comes into effect. What are the powers? So Inspector-cum-Facilitator powers are given. So authority and responsibilities, powers of Inspector-cum-Facilitator. First is the entry and inspection, like the previous labor laws. So enter premises at reasonable times, that is during working hours, examine and make copies of registers or documents, and say seize or take documents as evidence. So those powers are already there. Then there are examination powers. Question the employees or employers. So they can ask regarding compliance, require the production of documents, and take evidence of witnesses. So these powers are there. Thirdly, digital access. That means they can even take many things from your website. So access electronic records and verify online compliance. That is whether you are complying with the online provisions or not. So that will be done by the Inspector-cum-Facilitator. Next, maintain confidentiality. So that is their professional say ethics. Issue identity cards. Submit the inspection reports to the department or government, and recommend corrective actions before prosecution. So they will recommend corrective actions. They will give you time for rectification of deficiencies and provide compliance guidance. So these are the role as facilitator. Next, we see web-based inspection system. So how this digital transformation will come into effect. So digital inspection protocols are there. So there is technology-driven enforcement. So key features of this web-based inspection scheme. This is given under Section 5 of Wage Code. Similar provisions are there, say in other codes also. So firstly, appropriate government may lay down inspection scheme. Appropriate governments means central or state government for their respective powers as per the 7th schedule of the Constitution, because this is in concurrent list subject. What are the powers of rule making? So they are given under the respective codes. And what are the actual rules that will be notified by the when the rules come into effect, or when some of them have already come into effect. Central government has notified the draft rules for the time being. Must provide for web-based inspection, and online information calling mechanism will be there. Secondly, transparency measures, because something will be displayed on the website. So IT-enabled inspection system, this is mandatory. IT is information technology, okay? It is not income tax here. Transparency and accountability built in. So that is the advantage. And digital trail of all inspection. So they can trail it digitally also. Random selection. Computer-generated random inspection schedules will be there. So there will be online inspection, reduces harassment and bias. And even they may even use AI, just like they are doing at present in income tax. That means where they have to go for scrutiny, where they have to go for detailed examination or inquiry, like that. And ensures fair coverage. So there will be random selection to reduce this, harassment and bias. Next, we see the benefits. So reduce physical interface. It will there are minimized discretionary powers. Discretion is when something is not prescribed clearly in law. So at that time, the person has some discretionary powers. Vivekadhikar, क्या सही है क्या गलत है उसका निर्णय करना. So that will be minimized. Enhanced compliance monitoring, and there is real-time data availability. That is the advantage of web-based inspection. Next, we see inspection protocol and procedures. So what is the inspection framework under the 4 codes? First is the structured inspection processes will be there. So there is notice and for requirement, that is advance information. So it will not be surprise inspection. Timeline to be prescribed, that I am coming for inspection on so and so date, so and so time. Purpose of inspection communicated. What I will inspect, what documents I require. So that will be informed in advance. Scope of inspection, that is limited to matters specified in notice. So what is the scope of inspection? They will pay attention only to those things. So there will be prior notice. Random web-based selection. And so web-based selection will be there where they have to go for inspection. So they will be based on the employer's website. Next, documentation. So inspection report preparation is mandatory. So they will have to prepare these reports. Then findings recorded in prescribed format, that is prescribed under rules by appropriate government, and copy will be provided to the employer. That these are your what we have found in the inspection, and what are your deficiencies, and what is the time for rectification that is given to you for avoiding penalty and prosecution. Then Opportunity to rectify. This is critical innovation. This is a new thing because we have seen that now there is role of inspector-cum-facilitator. So before initiating action for violations, reasonable time shall be provided for compliance, that you have to rectify this within so many weeks or months. And exception is not available for repeat offences within 3 years. So if it is repeat offender and you have already been prosecuted earlier, this opportunity will not be there. What is the legal basis? Under Wage Code section 54 subsection 2 and similar provisions across all codes. Then we have opportunity to rectify. So what is the legal framework for that? There is pre-prosecution compliance window. That means there will not be sudden inspection or sudden prosecution. So groundbreaking provision under Wage Code section 54 subsection 2 is similar in other codes. Where a complaint is to be made, inspector-cum-facilitator shall give an opportunity to the employer to rectify the irregularities, if any. That means there will be a prior notice that these are your deficiencies and you have to rectify this within so and so time. So key conditions, first time violations only. It will not be applicable for repeat offenders. So not available for subsequent offences, and previous violation must be beyond 3 years. After 3 years, again, it will be considered new offence, not a repeat offence. If it is within 3 years, that will be considered repeat offence. And there is enhanced punishment for repeat offences, as we know. Specific violations are covered. That means non-compliance with code provisions, irregularities in maintenance of registers, whether they be manual or electronic registers, and payment-related defaults. So these will be the specific violations. Then time-bound rectification. That means reasonable period shall be prescribed as per the rules, and extensions will be possible with justifications. Impact of this is it will reduce litigation. That's why I have told that the role of advocates is now going to change. Instead of litigating lawyers, it is going to become more advisory role and due diligence advice to your clients. Promotes voluntary compliance and balances enforcement with business ease of doing business, so that we can attract more FDI to India. So it balances enforcement of laws with business ease. Next, we see maintaining statutory registers in electronic form. So digital record keeping mandate is there. It is mandatory now. So transformation from paper to digital. So because see, the older laws were from 1923 when the computers were not there. From 1923 to 2008, 29 laws have been repealed, and therefore there are revolutionary changes now because of computers and internet. Transformation from paper to digital is there. Legal requirements under OSH code section 9 subsection 1, every employer shall register his establishment electronically or otherwise. That means where or is there, your choice, you can register online manually also. Mandatory IT enabled systems are there. That means no paperwork allowed. So wage code for transparency and accountability. Just like there is say e-filing in case of income tax, it is mandatory in wage code, and all codes electronic maintenance is permitted. Next, we see registers to be maintained. So what are registered? Registers under different codes. So under wage code, there will be register of wages and salary. Now there will be different registers for women employees. So that is a new say innovation in this. So for male employees, female employees, there shall be different. You have to maintain different accounts, different registers. So register of wages and salary, register of fines that are recovered from say employees for their default. As we know, like payment of wages add, minimum wages add, etc. Register of advances. So advances and advance recovery. So there will be separate register and muster roll. Under SS code, that is Social Security, there will be PF contribution register, there will be ESI register, there will be gratuity register, there is maternity benefit register for women employees. So these are the registers to be maintained under SS code. Maternity Benefit Act has been repealed now. So that has been subsumed under the SS code, Social Security. Now, digital documentation standards are there. So OSH code. So what are the registers to be maintained? So electronic registers, register of say adult workers, that is above 18, register of child workers, that is 15 to 18, that is now prescribed. The older laws have been repealed. Leave register with wages, that will be separate register. Register of accidents, overtime register. For overtime, normally there is double payment at double the rate. So if some workers are working overtime, so there will be separate register for overtime, and register of contract labor and muster roll. These are the registers we maintain under OSH code. Under IR code, notice of change register. So under industrial relations, IR code, because the older laws have been repealed now, that is Industrial Disputes Act or say Trade Unions Act have been repealed. Register of strikes or lockouts, that has to be maintained, and trade union membership register. So these are the registers to be maintained under IR code. It is much simpler as compared to the previous 29 laws. Now the technical requirements are, first is the data integrity when there is electronic registers. So tamper-proof storage. So we have to take care of their security, cyber security, etc. Audit trail maintenance. That means the auditors shall also do it online as provided in the Information Technology Act 2000 as amended in 2008, which came into effect in 2009. Then backup and recovery mechanisms will be there when we have to take it up from say secondary storage. accessibility of registers. So available for inspection, downloadable in prescribed format, and real-time updates. These are the advantages. So accessibility has to be provided and has to be made available to inspectors when needed. Retention period, what is the lifetime electronic? So as prescribed, that is typically it is 3 to 5 years and longer for specific records. So for that time, the electronic registers have to be retained, maintained. Then self-certification mechanism. This is again a new innovation under the new labor codes. So empowering compliance through trust. So self-certification. What is self-certification? You can say generate your own certificate and print it. So employers certify their own compliance. So you have to self-certify. Then reduce inspection frequency and built on say trust, but verify the principle. So for that they will need the advice of practicing lawyers. So you have to advise your clients regarding this say self-certification, how they can do it, because there are many things that they will have to watch for in the new codes. Firstly, there is standing orders. The Industrial Employment Standing Orders as 1946 has been repealed. Instead of that, now there is IR Code Section 30. So employer can adopt model standing orders as is. So these are model orders, and the industries may or may not implement it as it is. So they may modify it, but these are the model orders, and they may implement or they may modify it as applicable in their own industries. And deemed certified without formal process. So without formal process, it is deemed to be certified and must intimate the certifying officer. So they have to implement that. We have brought this into effect so that they know about this. Safety compliance under the OSH code, because Factories Act has been repealed now. So occupational safety, health and working conditions. So self-certification for specified safety standards. Many safety standards were prescribed under the Factories Act 1948. Similar provisions are there now in the OSH code. Annual compliance certificates have to be there every year and subject to random verification. So that is safety compliance. Next we see verification mechanism, how it will be verified. So sample checks shall be done by authorities. Penalties for false certification, that will be there, and mandatory disclosures. That means you have to disclose it on your website that we are complying with so and so things. Benefits are faster compliance. That means greater trust. So these have been, we can say, deregulated. That means instead of a department doing, every employer has to do it, do it. So faster compliance will be there, reduce transaction costs, and encourages self-regulation. Then penalty framework. This is very important because every employer will want to avoid the penalties and prosecution. Criminal prosecution is also there. Firstly, there are increased penalties because under the older laws, as we know, they were from 1923, 1926, 1947, 48. So many different penalties have been enhanced. So increased penalties are there. So there is more deterrence, and there is shift in penalty philosophy. Under the old regime, it was low monetary penalties, that is rupees 100 to rupees 20,000. So it was there was no deterrent effect of that. Imprisonment for minor violations was there. Now there is less imprisonment and inconsistent across laws because different laws came into effect across a time frame of 100 years. Now what has happened in the new one? Under the new regime, there is significantly higher monetary penalties are there. That is, the range is 50,000 to 20 lakhs, proportionate to violation severity and differentiated for first and repeat offences. So those provisions are there, and there are separate chapters on penalties. You can go through that. They have already been published in the gazettes, which you can download from Ministry of Labour and Employment website. Imprisonment is reserved for serious violations, that is health and safety in hazardous processes. Secondly, non-payment of statutory contributions after deduction, because there is a welfare legislation. So always courts interpret it in the benefit of workers, and repeat offences within specified period. Graduated penalty structure is there. So for first offence, there is lower penalties or fines only. And for subsequent offence, there will be higher penalties plus possible imprisonment also. And of course, there will be notices from Inspector-cum-Facilitators. Now, let us see what is the penalty framework in detail. Under the wage code, that is Code on Wages 2019, that has come into effect on 21st November 2025. Section 54 is for penalty provisions. So payment less than due wages. Offence type is penalty. First offence, fine up to rupees 50,000, and repeat offence within 5 years. So imprisonment up to 3 months and or fine up to rupees 1 lakh. Under other contraventions, that is non-compliance with say provisions. So offence type is penalty, no imprisonment. First offence is say fine up to rupees 20,000, and if there is repeat offence, that is within 5 years, then there will be imprisonment up to 1 month and or fine up to rupees 40,000. Coming to the second code, so under wage code, third one is default in payment. There is under section 45 offence. So compensation up to 10 times the value of claim. Compensation has to be paid to the worker, the employee. So applies to minimum definitions are already given in section 2 of different acts. all four codes. Applies to minimum wages, statutory bonus, and wage defaults. Comparison with old law. So payment of wages at 1936, the maximum fine was rupees 7,500. Under minimum wages at 1948, it was max fine was rupees 20,000. Under payment of bonus at 1965, that has also been repealed now. There was imprisonment of 6 months plus rupees 1,000 fine. So this is how it has changed under the wage code. Coming to the industrial relations code. So penalty under IR code, section 86 is about that. So enhanced penalty structure is there. So first is the retrenchment or closure violations. So offense type penalty, first offense fine up to rupees 2 lakh, and for subsequent offense imprisonment up to say 6 months and or fine up to rupees 5 lakh. There is unfair labor practices. This definition, those who have studied labor law already know about this. Labor courts decide what are unfair labor practice, and if there are say challenges, then in litigation, in their judgments, it's a term something as unfair labor practice, and for that there could be fine. So maximum fine is rupees 2 lakh now. Failure to certify standing orders. Now the industrial employment standing orders at 1946 has been repealed. So instead of that there is IR code. So maximum fine now is rupees 2 lakh, and compare the old law, penalty was only rupees 5,000. That had no say, very less deterrent effect. For illegal strikes or lockouts, so breach of notice provisions during prohibited periods, and penalties are proportionate to disruption caused. So there could be penalties on workers also. Now comparing old versus new, IDA highest penalty, Industrial Disputes Act. Earlier it was 5,000 because it was 1947, and under IR code, highest penalty now will be 5 lakh. That is 100% increase is there. So from 5,000 it has increased to 5 lakh because after 1947 now there is going to be Vikasit Bharat in 2047. So these changes have come. Now penalty framework under OSH code. So penalties under OSH code 2020 sections 94 to 103, they provide for penalties. So comprehensive penalty structure is given. General contraventions, maximum fine was rupees 5 lakh. Health and safety in now it is say under the OSH code it is 5 lakh. Health and safety in hazardous processes. So first offense imprisonment plus fine, enhanced for serious violations, and there is corporate liability provisions. For employment of women or contract labor violations, then maximum fine will be 1 lakh in such cases. Then if there are continuing contraventions, so additional daily penalty, that is per day of contravention, and there is multiplier effect for persistence. Then failure to obtain registration. This is very critical. So consequences, disbarment from employing employees. So they could be debarred, that you can't employ anyone. Then potential business shutdown could be there, and for more severe than mere monetary penalty. So that could be there if there is failure to obtain registration. Comparison. So if we compare with factories at 1948, max fine was rupees 1 lakh for hazardous processes, and under OSH code it is now up to rupees 5 lakh. Coming to the third one, Social Security Code. So penalties under Social Security Code 2020, sections 133, 134 provide for say penalties. So Social Security violations, most severe penalty, that is misappropriation of contribution offense. That is instead of employee's account, say employee transfers it to own account. That is called misappropriation, or criminal misappropriation could be there. Just like 403 was there, criminal breach of trust. 405, 409, 409A were there in IPC. Now there is BNS there. So penalty is failure to pay contribution. This is deducted from employees' wages, and imprisonment up to 3 years and or fine up to rupees 1 lakh. For non-payment of benefits, offense type is penalty. So first offense, in case of first offense, and imprisonment and or fine. So that varies by benefit. And for second or subsequent offenses within specified period, imprisonment up to 3 years and or fine up to rupees 3 lakh. So these are the new provisions. Coming to the say filing false returns, third type of offense. So significant penalties are there. Criminal liability is also there. For obstruction of authorities, say imprisonment provisions are there, and enhanced fines are there. So key benefits covered here under Social Security Code are gratuity, maternity benefit, ESI, PF, compensation, because all these older acts have been repealed now. Then there is compounding of offenses. Compounding, as we know, it is like compromise. Just like there was 323 and 21 under CRPC 1973. Now that has been say repealed by the BNSS. Similarly, here is compounding there, compromise. So settlement without prosecution. So this revolutionary concept in labor law. What is compounding? It is a mechanism to settle offenses by paying fine. It avoids criminal prosecution and one-time opportunity for first-time offenders. So legal provisions are there. Wage Code section 56, IR Code section 89, OSH Code section 114, and SS Code section 138. So these are the 4 sections where compounding provision is there. Eligibility, it is for only first-time offenders, not for repeat offenses or repeat offenders. So no previous conviction for same or similar offense, and it's a clean record for specified period. So for first offenders, it is there. Earlier, in CRPC also we had similar provisions like Section 360, Probation of Offenders Act 1960, and say UP First Offenders Act 1938, etc. are there at state level. So this is similar to that. Offense type restrictions. So only specified offenses are compoundable, and serious violations are excluded from compounding. Then the payment structure. So quantum of compounding amount. So payment formula is offenses punishable with fine only. So compounding amount is 50% of maximum prescribed fine. So if there is compromise, then it has to be 50%. So for example, if max fine is rupees 2 lakh, so pay rupees 1 lakh. And that way there can be compromise. Offenses punishable with imprisonment. So up to 1 year plus fine. So compounding amount is 75% of maximum prescribed fine. Example is if max fine is rupees 1 lakh, then pay rupees 75,000. So that is compounding. So the compromise can be reached like this. So this has been legally provided now. For the process is application for compounding has to be filed that we want to compromise, payment of compounding amount, and acknowledgement from authority. So it has to acknowledge. No prosecution is instituted once compounded. So that is the advantage. Criminal prosecution can be avoided. Restrictions are not available for repeat offenses. 3-year look back period for similar violations. So they will check your record or say prosecution record of 3 years. Cannot compound after final conviction. So once final conviction is there, judgment is pronounced, then the compounding can't be done. It can be done only while the pendency of litigation. Some serious offense or before litigation. Some serious offenses are non-compoundable. So it is not available for all offenses. So it is given in the 4 codes as we have seen earlier. Next, we see what are the practical implications of the new provision. So strategic considerations for employers are of cost. You know how much has to be paid. No negotiations. Koi mol bhav nahi. So known upfront payment is known. No litigation uncertainty. Time and resource savings. So it avoids say protracted court proceedings so that you can avoid that tarikh pe tarikh, and reduces legal costs. So this is a big advantage. No criminal record. So clean state has to be maintained. Reputation protection is there. So that will be there. And business continuity. That is quick resolution is there. And there is minimal disruption. Like happened when there were strikes, lockout, retrenchments, etc. under the older IR laws. Next, we see the practical implications of this. When to compound and when not to compound. So when to consider compounding? First time minor violations, technical non-compliances, when rectification not possible, and cost benefit favors settlement. So at that time, compounding should be done. When not to compound, when violation is contestable. That means if you can say consider that you are going to win that case or it is contestable. Secondly, authorization overreach and precedence concerns for organization. So you can see, check the previous record and like that, say when there is authoritarian overreach is there, that is misuse of authority, etc. At that time, compounding is not done or cannot be. So you have to check those compounding sections under the 4 codes. Now the limitation periods. Or limitation is generally we already know about limitation at 1963. Within how much time you can go to court or you can challenge certain provision. That is called limitation. The aim is to reduce litigation in courts. So time limits for claims and proceedings. That is the claims has to be filed within these dates and proceedings have to be completed within such this time frame. So unified litigation framework is there. Under old regime, it was largely silent or open-ended, different periods under different laws and uncertainty for employers. Now there is time bound there to end this tarikh pe tarikh system. Firstly, there is wage code, section 45. So prescribed limitation periods are filing of claims must be within 3 years from date claim arises and extended from 12 months under payment of wages at 1936. So earlier it was 12 months. Now it has been extended to 3 years. It is more beneficial to employees as we can see this under the new law, new code. IR code, section 53. So conciliation proceedings have to be initiated within 2 years from date dispute arose. Individual dispute for tribunal within 2 years of say discharge or retrenchment, and say GRC application is 1 year from cause of action. So for general regulatory compliance under IR code, it will be 1 year. SS code, section 125. So PF or ESI proceedings have to be done initiated within 5 years from date of cause of action. Impurities, inquiries must conclude within 2 years. So that is the maximum period. So this conclusion is also given that within 2 years it must conclude. Then practical impact of this is strategic implications for litigation. So impact on claims is for employees or workers, there are benefits, extended window to file claims, especially wage code. So as we have seen, instead of 1 year, 12 months, it is now 3 years. Must be vigilant about limitation periods. Otherwise, the labor code may say that you are slipping over your rights and now because of latches, the case is dismissed or the claim is not given. Sufficient cause provisions for delayed claims. So if sufficient cause is there, then the labor code or the presiding officer, now there could be division bench also. So there could be two say judges in labor code instead of one as provided under the older acts. So that is again change in labor courts. For employers, advantages, certainty in say liability exposure, time-bound claims can be dismissed at threshold. So that can be contested while filing the reply, and document retention requirements clearer. That is, what is the retention period of different documents, for how long you have to maintain the manual or electronic registers. These are the practical impacts. The challenges are longer exposure period, 3 to 5 years, because now the labor is given more time. So the limitation period is there. And since this is a special law, so the provisions of limitation at 1963 won't apply. It is a general law. Need for robust record keeping and potential for revival of old disputes is there under the new laws if the cause of action arose earlier. Judicial discretion. So authorities may condone delay with sufficient reason. So that has to be grieved by the defaulter or those who have filed the claims late. Case by case assessment and need to demonstrate genuine hardship. So practice tip is document retention aligned with longest limitation period. That is 5 years under SS code. So that after that they can be destroyed. So this is the life of manual or electronic registers that have to be maintained. So that is given under the limitation period. Now bar on jurisdiction of civil courts, that is already there in most of the acts where there are different courts, tribunals or commissions have been established. So these cases can't go to ordinary civil courts because these will always go to the labor courts. So exclusive jurisdiction of labor authorities. So ousting civil court jurisdiction, legal provisions are each code contains specific provisions barring civil court jurisdiction. Under wage code it is section 52, under IR code it is section 93, OSH code section 116 and SS code section 143. These are the new provisions that debar the jurisdiction of ordinary civil courts. Secondly, what is the effect of this? So matters covered by courts, statutory authorities have exclusive jurisdiction and civil courts cannot entertain suits or proceedings on code matters, that is labor codes. And alternate dispute mechanism, resolution mechanism under codes is available. Rationale of this is specialized tribunals or authorities for labor matters. Generally, the Deputy Labor Commissioner or DLC, as we know. There is CLC, Central Labor Commissioner under central government. So speedy resolution is there. Expertise in labor jurisprudence. Exceptions are constitutional remedies are there. Writ jurisdiction. So they can go to High Court. That is always available because they are constitution and constitution is above all these laws of Parliament. And appeals as provided in courts. So these appeal provisions are there in different courts and jurisdictional challenges could be there. Next, we see what is the joint liability in transfer of establishment. So shared responsibility in business transfers under SS code, it is section 145. Joint and several liability framework. Severally separate. So pruthak, different liability. So scenario is when employer transfers establishment, whole or part, transferor, that is the original employer, and transferee, that is new employer. So both jointly and severally liable, that is jointly as well as individually liable for dues arising before transfer. So that is the joint liability. Next, what is the scope of this liability when the in case of transfer? So transferee's liability is limited to value of assets obtained by transfer and not unlimited personal liability. Pre-transfer dues are covered. So unpaid PF contributions, ESI arrears, gratuity liabilities, other social liability security obligations have to be met. So example is A Limited transfer part of business to B Limited. So A has unpaid PF dues of rupees 10 lakhs. B acquires assets worth rupees 15 lakhs. Both A and B are liable for rupees 10 lakhs. And B's maximum liability is rupees 15 lakhs. That is the asset value. So this is how we can calculate. And for that, of course, people are going to need legal advice. And there the role of advocates in advisory capacity comes into play. Next, we see practical implications of this joint liability cases. So due diligence in business transaction, impact of on corporate transactions for transferees, that is buyers. Critical due diligence areas are social security and compliance, social security compliance audit, that is SS. So PF ESI payment status, gratuity fund or insurance status, outstanding maternity benefit claims, employees comparison compensation pending. So this we can say is a form of checklist. What are the documents or status that has to be checked. Secondly, documentation review. So returns filed and accepted, inspection reports and compliance status, and pending litigation or notices. Financial assessment. So quantify the potential liabilities, escrow arrangements, and indemnity clauses if there is some insurance in agreements if they exist. So that has to be checked. For transferors, that is sellers, clear all dues before transfer, obtain clearance certificates, and minimize post-transfer liability so that the unnecessary litigation can be avoided. Contractual protections. So representations and warranties are there. Holdback amounts could be there. and indemnification mechanisms could be there, like third party or insurance or guarantor. Then challenges in digital transformation. So what are the problems likely to be faced by employers or employees, or say lost ones and lawyers? So implementation hurdles and solutions are: current challenges are technology infrastructure. So common portal not yet fully operational, but it's going to be operational soon, and it differs from state to state as well as central level. State level portals at different stages are there. Integration issues between systems. The rules finalization. So most states have only draft rules, so they will be notified, and the work has already started, and many draft rules have been finalized and come into effect and notified during last 2 months, that is after 21st November. And uncertainty in compliance requirements and frequent changes are expected. So one has to be continuously vigilant on central government as well as state government websites of your labor and employment department. Capacity building. So that is the third one. Employers need training on new systems. Inspector-cum-Facilitators need orientation. So training programs are being conducted for them also. And workers need awareness. Trade unions also. Legacy data migration. That is the older data. So existing records are to be digitized. Data format standardization and historical liability assessment has to be done. And there they might need technical or legal advice. Concurrent legislations. So state shops and establishment acts continue. They have not been repealed. So they differ from state to state. They will be there. Potential conflicts in provisions could be there, and then the matter could be resolved by the, say, constitutional courts, that is Supreme Court and High Courts, and say harmonious interpretation required. It is a basic rule of say jurisprudence, interpretation of statutes, as we know. What is that? Harmonious means when one thing is written in one statute, another is written in another statute, then we have to do the interpretation in such a way that neither this nor that is violated. This is called the golden rule of interpretation. This is harmonious construction of meaning, arthaghatan in Hindi. Next we see solutions and best practices navigating the transition. So enforcement approach, say recommended approach for employers is what has to be done within say 0 to 3 months, that is after November. So compliance audit. So map the current compliance to new costs, new codes, identify what are the gaps and non-compliance, and assess cost implications, because the penalty provisions are also there, and now there are say enhanced penalties. There are say greater penalties as compared to the older laws. Registration updates. Verify the demand registration status, because earlier there were 8 registration, now there is only single one. So even if one is going to expire, there could be requirement of new registration and updation. Update the establishment details and obtain necessary new registrations. Definition of establishment is already given in section 2 of this course. Policy review. So align internal policies with codes, update employment contracts, that will be there, and that is where they need services of advocates, and revise the HR manuals, because even HR manuals will have to change to be in alignment with the new industrial or say labor laws. Next, medium term. What is to be done over the next 3 to 6 months? So medium system upgrades, that is implement HRMS, HR management system, aligned with these new codes, electronic register, training programs, that is HR team on new provisions, finance team on wage calculations, and legal team on litigation strategy. Some of these I am advising here also for litigation for lost ones as well as for practicing advocates. Next, best practices. So what is to be done? So proactive compliance strategy over the next 6 to 12 months. Firstly is the process re-engineering, that is streamline the compliance workflows, integrate with payroll systems, centralize compliance dashboard. Vendor management, that is contract labor agreements review, manpower supply contracts update, and liability allocation clauses. Then governance framework, that is compliance committees, regular internal audits, and management reporting mechanisms will be there. So these are some of the best practices that need to be implemented in next 6 to 12 months, when the say EPF and ESI will be fully say older will be repealed and new will come into effect. Technology solutions are there. So cloud-based compliance platforms could be there. Cloud-based services could be there. Private clouds, public clouds, hybrid clouds, different types of cloud technologies are available. If you don't have your own infrastructure, technical infrastructure, AI-powered register maintenance could be there. That provides better vigilance and monitoring, supervision. Real-time alerts for compliance deadlines, so that you get timely reminders, so that you don't miss any deadline. Integration with government portal, that is the advantage. Legal support, so retainer with labor law specialists, periodic compliance health checks, and litigation readiness protocols. So these have to be formulated by the practicing advocates, particularly those who are going to practice in the labor courts. Now the role of legal professionals. So let us focus on this. So opportunities and responsibilities are there for advocates, advisory services. Firstly, the compliance consulting. See, initially there will not be any litigation under the new laws. So what they have to do, audit and gap analysis, policy drafting and review, implementation roadmap. So these are the services that are required. Secondly, transaction support. that is due diligence in mergers and acquisitions, M&A, draft indemnity clauses where the insurance or guarantors are there, liability assessment has to be done, litigation strategy, that is pre-litigation settlement, representation before authorities, and appellate proceedings, keeping in mind the new say court structure as well as the limitation periods. Then emerging process practice areas that will be there. Firstly, digital compliance advisory. Another one is technology and labor law interface. Then gig economy and platform workers, because as we know, this is going to affect over 40 crore say workers in India. Earlier it was less than 20 crore people. So now these gig workers and platform workers are also being given SS benefit, social security. They are now going to demand under the IR laws also that they should have the powers to say have form trade unions, etc. Those things are political. They are going on already. Then cross-border labor compliance, continuing education, that is stay updated with the rules notifications, track judicial interpretation, that is the new case law, and study the comparative jurisprudence. That is what things have become inapplicable and what will remain applicable under the newer laws, because many of the older provisions have been repealed. So where they are not applicable, the older case laws have become irrelevant and they are not to be followed. But if they are same, then the older laws may be valid. So that we have to check as advocates. Then key takeaways, say digital transformation. So we can summarize the summary of physical digital compliance framework, what we have seen in this presentation. So revolutionary features are, firstly, the single registration portal will be there. So one window for all compliance, unified licensing, that is common license for multiple activities. There will be integrated returns. So one return, multiple obligations, electronic registers, so digital record keeping mandate, web-based inspection, that is random, transparent, and IT enabled, and self-certification. So trust-based compliance will be there, and deemed approval, that is automatic approvals if not processed in time. The philosophy is from compliance burden to compliance ease, from prosecution to facilitation, from physical to digital, and from complexity to simplicity. That is the summary. Next, enforcement framework. What changes have happened? So summary of penalty and enforcement mechanism, balanced approach is there, what we have seen today. Employer friendly, so opportunity to rectify before prosecution, compounding of first time offenses, decriminalization of minor violations, penalty is even, fine is criminal. So you have to see that word, whether it is penalty or compensation or fine, etc. One has to be very clear about this. Clear limitation period, deterrence, that is significantly higher monetary penalties, that is up to rupees 20 lakhs are there under the new codes. Imprisonment for serious violations, enhanced penalties for repeat offenses, joint liability in transfers. Key success factors are proactive compliance culture, technology adoption, and regular audits and updates, professional legal support. These are the comparative chart, what has changed. So number of laws, instead of 29 central plus newer state laws, now there are 4 codes. Registration, multiple. So earlier it was PF, ESI, factories, etc. Now there is single common registration. Returns, earlier there were multiple separate returns. Now there is unified single return. Inspections, were physical and discretionary. Now it is web-based, random, and transparent. Inspector role, it was enforcement only. Now it is Inspector-cum-Facilitator. Penalties, earlier it was rupees 100 to rupees 20,000 frequent imprisonment. Now it is 50,000 to rupees 20 lakh and selective imprisonment. Records, earlier it was paper based. Now it is electronic or digital. Approval process was manual and lengthy. Now it is a self-certification as well as deemed approval. These are new provisions that have come into effect. Rectification, say no statutory provisions, opportunity before provision. Earlier, the limitation period was say 3 years. So that was unclear or open-ended. Now it is say clearly defined, that is 3 to 5 years. So that is the change. So this is how we can summarize this. What is the future? So what we expect to in coming months? Anticipated developments are Q1 to Q2 of 2026. So finalization of rules by remaining states, operationalization of common portal, guidelines on web-based inspection, and floor-based wage rectification. We should be on lookout for that. Floor wage notification. Floor wage will be national level, national ceiling under like minimum wages act. Q2, Q3 2026. First round of we already discussed this floor wage under the in our previous 2 sessions. They are available on YouTube. First record of inspections under new regime. Then judicial interpretations begin, and technology platform stabilization and employer feedback incorporation. That is expected in Q2 to Q3 of 2026. What we can expect beyond 2026 next year? So integration with older compliance regimes, AI-powered compliance monitoring, predictive analytics for risk assessment, and cross-border digital labor compliance. Judicial developments could be High Courts and Supreme Court to interpret the provisions, doctrine of harmonious construction with state laws, and as per the 7th schedule of Constitution, and constitutional validity challenges, if any, arise. Critical action points are, so immediate steps for stakeholders, for employers, conduct comprehensive compliance audit now, register update on common portal, digitize all statutory registers, review and update all employment contracts and policies, train HR, payroll, and finance teams, engage labor law specialists, and set up internal compliance monitoring. For advocates, deep dive into all 4 codes and available rules. They are available on this MOL website, Ministry of Labor and Employment. Track state-wise rule notifications applicable to your states. Develop exercise expertise in digital compliance. Offer compliance audit services. Build litigation strategy for new regime, because new court cases are likely to arise after a few months. Network with inspector-cum-facilitators. For workers or trade unions, understand new rights and remedies under the new laws. Learn limitation periods for claims, because now they have been increased because there is a welfare legislation under DPSP of Constitution. Familiarize with digital complaint mechanisms. So this is a new thing. Essential materials for this is my resources and references what I have referred. Primary sources are the 4 codes, Bare Acts, that is Code on Wages 2019, Industrial Relations Code 2020, OSH Code 2020, and Code on Social Security 2020. Central rules draft have been notified already. They are available on MOL website. Then state rules. So Gujarat, Arunachal Pradesh, Bihar, they have finalized. Other states, so track notifications of your respective states. Official portals are Ministry of Labor and Employment, labor.gov.in, EPFO, epfindia.gov.in. Older benefits will continue for up to 21 November 2026, as I have told earlier, and clarified by the government on 19 December 2025. ESIC, so esic.gov.in. Reference documents are Government of India publications on labor codes, say NASCOM handbook, that is National Association of Software and Service Companies. I am computer engineer also. So NASCOM handbook on labor codes, April 2024, and industry-specific compliance guides. Case studies are there. Scenario 1. So digital compliance success story, like IT company with pan-India operations. Background is say Tech Corp India Limited, 50 offices across 50 states, 10,000 employees. Previously, say 150 plus separate registrations and licenses. Challenges are now multiple state compliances, different filing timelines, high compliance costs, frequent inspector visits. Now what will happen? Solution under new codes will be single registration, one common portal registration, unified returns, consolidated monthly return filing, web-based inspections, that is random, scheduled. That is prior notice will be there from inspector-cum-facilitator, no harassment, self-certification, annual compliance certificate, that has to be self-generated, self-certified. Then electronic registers, that is cloud-based HRMS, human resource management system integration. Results are 70% reduction in compliance time, 60% reduction that is estimated in compliance costs, zero inspector harassment, enhanced transparency. Second one, factory say penalty mitigation through compounding. So this is a new provision, compounding under all the 4 codes. So scenario is manufacturing, say unit with technical non-compliance. Background is say ABC Manufacturing Limited, 500 workers. First time say minor violation detected during inspection, violations identified, delay in PF deduction, deposit, inadvertent, incomplete say entries in wage register, non-display of say abstract of wage code. So prosecution risk was under the old regime, criminal prosecution for each violation, imprisonment possibility, reputation damage. Now what happens under the new laws? So under new laws, opportunity to rectify. So given 30 days to correct register entries, display the abstract immediately, and deposit PF with interest. Compounding application is there. So applied for compounding of offences. Compound amount is also already given in the code. So paid 50% of maximum fine, that is rupees 25,000. No prosecution, so matter closed. Outcome is business continuity is maintained. Lesson learned. Third scenario, joint liability in business transfer. So scenario, acquisition with hidden liabilities. Background is target company selling business unit to buyer company. So 200 employees to be transferred. Undisclosed PF area rupees 50 lakhs. Issue discovered post closing. So PF inspection related revealed non-compliance. Demand raised on buyer company. Legal position was now there is SS code section 145. So both target company and buyer company are jointly liable. Buyer's liability is limited to asset value, that is rupees 2 crores. So this is the advantage. And resolution is buyer's action. So invoked say indemnity clause in shared purchase agreement, claimed against say escrow amount and recovered to the authorities, so paid arrears with interest, obtained clean sheet. No criminal prosecution. Lesson learned is comprehensive under say labor due diligence is mandatory, adequate escrow say holdback essential, and joint liability clause awareness critical. So now some frequently asked questions are there. FAQs on digital compliance. Is physical maintenance of register still required? No. Electronic maintenance is expressly permitted and encouraged. However, ensure data integrity, backup, and accessibility for inspection. Second question, what if common portal is not yet functional in my state? So continue with existing registrations. Once portal is operational, multiple data within prescribed, migrate data within prescribed timeline, and existing registration deemed valid. So there is no panic situation. Can we use third-party software for statutory registers? Yes, that is permissible. Yes, provided it meets a prescribed format. That is the legal framework. and data security requirements should be integration ready with government portals. So that compatibility has to be there, technical compatibility. Next question, how often will web-based inspections occur? First, it is random selection by computer system. Frequency depends on risk categorization of establishment. This is yet to be prescribed under rule. Is self-certification mandatory or optional? So it is optional for most provisions. It is mandatory for specific areas like adoption of model standing orders, incentivize compliance through reduced inspections. Next question, can we compound an offense after prosecution has started? Yes, compounding can be done. So compounding is permitted even after prosecution litigation, but before final conviction. However, better to apply early. Next question, does opportunity to rectify apply to all violations? No. It is not available for repeat violations within 3 years, for serious violations, that is health and safety hazards, and for willful non-compliance, that is deliberate. What if we disagree with Inspector-cum-Facilitator's finding? So grievance redressal mechanism is available and can approach appropriate, say, appellate authority. So their orders can be challenged in appeals, and final recourse to courts, that is labor courts, on jurisdictional or legal issues. And uske upar High Court, Supreme Court to hai. So are limitation periods absolute or can they be extended? So authorities may say condone delay if there is sufficient cause shown. However, burden of proof is on applicant who delays, defaulter, or who has delayed. Document genuine reason. And last question is, do higher penalties apply retrospectively? No, penalties applicable at time of offense, because as per Constitution, Article 20, Clause 1, it can't be applied with, say, retrospective effect, that we already know. So new penalties apply only to violations after code implementation, that is 21st November 2025 onwards. So these are practical tips for compliance. Best practices checklist. Documentation, maintain comprehensive records for 5+ years. Digitize legacy documents. Regular backups and data security. Proactive monitoring. So monthly compliance dashboards. Real-time alerts for deadlines. Annual internal audit. Policy updates. Review policies quarterly. Train employees on changes. And communicate through multiple channels. Then technology investment. So robust HRMS with code compliance modules, integration with government portals, and automated return generation. Professional support. So engage labor law specialists, regular compliance reviews, and litigation preparedness. Stakeholder communication. So clear communication with workers, transparent with unions, and response to authorities, that is government authorities. Now ethical considerations, professional ethics for advocates. So advocates in labor matters. So client counseling. So advise proactive compliance over post-facto defense. Discourage non-compliance for cost savings, and emphasize long-term reputation and sustainability, because everybody wants to be on the right side of the law, not on wrong side of the law. They want to avoid penalty and prosecutions, and that's why they are likely to take your advice. Dealing with Inspector-cum-Facilitators, no inducement or obstruction, and cooperation in inspection process. Then worker rights. So balance employer say interest with worker welfare. Recognize social justice dimension, because courts always interpret it in favor of workers normally. Promote fair resolution. Compounding versus contesting. So objective assessment of merits, cost-benefit analysis for client, and ethical limitations on settlement. This is where advocates' advice will be needed. Documentation. So accurate records and representations, no false certification, and maintaining say attorney-client privilege as per the say Evidence Act. Bharatiya Sakshi Adhiniyam now. So remember, labor law in social welfare legislation interpret liberally in favor of workers where ambiguous, because the courts also do like that. Now the emerging trends in this, future of labor law compliance in India, technology-driven compliance. So AI will be used in future. Predictive compliance analytics, risk assessment algorithms, and automated return preparation. Blockchain technology will be implemented. So tamper-proof wage payment records, smart contracts for say statutory obligations, transparent audit trails. Internet of Things, where other things will also be connected to internet besides computer, laptops, and say mobiles. So real-time like vehicles, etc. So real-time safety monitoring in factories or other machines. Automated working hours tracking, and environmental compliance sensors could be there. Then gig economy regulations will come, because they have been implemented. Process code provisions, aggregator obligations, new employment relationship models. Cross-border implications, so remote work compliance, because there is say platform workers are also included within this new codes now, particularly SS code. International social security agreements, and digital nomad labor rights, that is people migrating from one state to another state or one country to another country. Sustainability and ESG, so labor compliance as say ESG metric, and investor due diligence focus, and corporate governance integration will be there. So we can conclude, embracing the new labor law paradigm, transformational changes. The new labor codes represent the most significant reform in Indian labor law say since independence. Consolidating 20 laws into 4 comprehensive code. The paradigm shifts are ease of compliance over enforcement burden, digital transformation over paper-based systems, facilitation over prosecution, self-regulation over inspector raj, and unified framework over fragmented laws. Challenges ahead are full implementation dependent on state rules, technology infrastructure development, capacity building of all stakeholders, harmonization with state legislations. Opportunities are streamlined compliance, reduces costs, transparency processes reduce corruption, enhance worker protections, and boost to ease of doing business. So call to action is the time for preparation has already passed. They have come into effect. So the time for implementation is now. These are references. So professional development. So attend workshop on labor codes, subscribe to Ministry of Labor and Employment updates, join professional networks and forums, continuing legal education. So webinars on practical implementation, case law updates as jurisprudence develops, and state-specific compliance trainings. Then resources are Ministry of Labor and Employment, labor.gov.in, legal databases for updates, industry association, guidance materials. So thank you for your attention, questions and discussion. Although I have already covered the frequently asked questions, and we can discuss on this topic, suggested topics, state-specific implementation challenges, technology solutions for compliance, litigation strategies under new codes, and sector-specific compliance issues.
Sir, registration form, there is one question you have discussed, but sir, in nutshell, can you again discuss the opportunities for legal professionals with regards to compliance and consultation?
Yes. Firstly, see, instead of adversarial litigation, now there, as we have seen, the main change is now there will be advice, because everybody wants to be on the right side of the law. So there is due diligence guidelines that we have to give to our clients. Firstly, how they can avoid the prosecution and penalties. So that is there. Secondly, electronic transformation, this digital transformation, that is most of the things are going to be online now. So in this we have to do. And as far as the strategy is there, so the scope for advocacy was always there. Earlier also it was there, now also it is there. So we have to update with the new laws, particularly the what are the legal recourses that are available. For example, compounding, if it is repeat offense, what are the powers of different courts, because there will be now say division benches in labor courts also, instead of single presiding officer. So these are some new changes that have happened, and maybe we can hold further webinars also on these provisions, because there are many. See, actually we have not even seen these 4 codes in details, so there will be 4 presentations on these 4 codes also independently. For the time being, we have covered here only 2 topics, that is compliance framework as well as the digital transformation.
Okay, sir. Sir, and are there any measures taken by the states to train the workmen?
Yes, state is doing that. See, firstly through trade unions, because training is needed for all. Even it has already started, and it was going on since last 5 years. It was going on for labor department officers, because these were laws have already been codes have already been passed by parliament. They have been assented to by the president, and the draft rules were formulated by many states. So already the labor codes, or say who are getting training in judicial academies, and labor welfare officers and department officers, they have mostly been trained. Just like in new criminal laws, we have seen that within 6 months they train more than 5,65,000 say policemen and advocates and judges. So here also that is there. Now what is needed is training of say employers, training of employees, and training of advocates and law students. Here it was targeted mainly towards advocates and law students, but there is need of training for employees and particularly the employees also, because now there are the scope has changed. There are gig workers, there are platform workers. Gig workers are like people who are bringing the parcels to our home, like this Amazon, Flipkart, Swiggy, Zomato, and Snapdeal, and all these will be under the SS framework. So that has changed. And platform workers, people who are working online, work from home, particularly the people who are retired, people who are unemployed, or people who are doing independent practice, or those who are working for clients abroad, or housewives. So these are the say clients, say potential clients, and that will be there, and training is needed for them.
So one more question from registration form. What are the mechanisms for consultants? How are consultants protected under the new code?
For consultants of what?
Sir, I think professional consultants.
Professional consultants, see, their role has now enhanced, because see, everybody wants say this due diligence compliance or advice. So instead of receiving notices from say inspectors or inspector-cum-facilitators, say so for this consultant, there is more scope now as compared to the older laws, because there will be more advice. And as I have told, instead of advocates or litigation or adversarial practice, there will be more say compounding and more say advice. and that's how the role has changed for consultants. So they will have to update themselves with these new codes and then offer professional advice to their clients. So there is, I think there is much scope for the say consultants, provided they upgrade their knowledge under the new codes.
Sir, thank you so much for such an enlightening webinar. And हमेशा आप इतने efforts लेते हैं ये PPTs बनाने के लिए. All our students are really getting to learn so much from your sessions. Thank you so much, sir.
Thank you. My aim is to bridge the gap between say law colleges and as well as the practicing advocates. And
Yes,
the
sir.
new laws are coming. So दूसरों को knowledge देने से अपना भी knowledge बढ़ता है. So I'm thankful to PLEA for giving me this opportunity on their platform. इसका consent भी YouTube का मैं दे दूंगा. Okay.
जी sir, sir. Thank you, sir.